Until recently, when the laws were changed, the only thing that was referenced in the statutes was a proxy. And so when dealing with absentee ballots, professionals, managing agents, people involved in the operation and governance of associations would use the word proxy and then differentiate that proxy into two parts. So it would be the directed proxy and the regular proxy. And the directed proxy was basically the absentee ballot. And so the way the statute was applied before recently was to find that the word proxy in the existing laws covered absentee ballots and proxies, because a directed proxy was considered an absentee ballot. The recent changes to the law make it clear that there is actually now a legal distinction in a variety of ways, not only in the name, between an absentee ballot and a proxy ballot. Interestingly, under current New Jersey law, there really isn't anything that governs the eligibility or sets the eligibility of a proxy holder. There are rules and regulations that govern the nature of the proxy, what has to be in it, how long it'll last, what it's for, but nothing that dictates the eligibility of a person to actually be a proxy. There's some presumptions that are made, presumably, that a proxy holder would have to be someone who's of mature age, over 18, competent to carry out the desires of the person or the entity that issued the proxy. But other than sort of a generalized, competency and age, there really is no limitation at all to the ability of a person to be eligible to be the proxy holder, not the person that gave the proxy, but the proxy holder. It is important when an association is preparing and then sending out a notice of an election to be mindful of the various aspects of the process. So for instance, the notice under current law will have to contain certain things, certain information, some of import, some of less import, but all of it will have to be consistent with the proxy and or the absentee ballot, depending upon which one you're going to use, if not both of them. So in the past, associations would often focus the notice on just simply the details of the election itself, location, time, that sort of thing. And then the ballot could could basically be done before the election actually took place. That's important now, though, that all of it pretty much be done at the same time, because everything has to be consistent and has to contain certain references that you would not be able to differ from when you went to finally do the ballots before the election. Following the new laws and statutes that deal with elections, there are now differences between large associations and small associations. The difference is basically 50, and there are differences. When it comes to the absentee ballot, the proxy ballot, there really is one big distinction. And the one big distinction is that the larger association must create an availability or an ability for the voter to have a write-in ballot. The small association does not. The small association has the power to allow for write-in candidates, but need not do it. And the large association must allow for write-in candidates. So the small association, when it creates its absentee ballots, for instance, it doesn't necessarily have to have an area set aside for write-in ballots. But the large association, when it does its absentee ballot, would have to set aside an area for write-in candidates. And an association does have the ability, provided it meets a certain number of requirements, that electronic voting be utilized. And when it comes to absentee ballots and proxy ballots, that still remains the same. It is easier with respect to the smaller association, vis-a-vis absentee ballots and proxy ballots, because the small association has more flexibility as to whether or not to even have such things. Now, when it comes to smaller associations, proxy ballots, unless they're specifically prohibited, have to be allowed. And when it comes to larger associations, the regulations specifically say that even if you're going to have electronic voting, which is appropriate and acceptable, there still needs to be a mechanism by which absentee ballots and proxy ballots can be utilized, and specifically a way in which they can be preserved. So you can, if you're going to have electronic voting, which is okay, you're going to still have to allow people to utilize the proxy and or the absentee ballot, and you're going to have to make sure specifically that all these votes, whether they're cast electronically or by the absentee or proxy ballot, are maintained after the fact. Until recently, the only limitation on the only control on the proxy as to validity was just whether it had any indicia of fraudulent, any indicia that it was fraudulent. Currently, though, a proxy, when it's used, has to have very specific things. It has to set forth that the proxy is voluntary, that the proxy can be revoked, that if the proxy is going to be used, that an absentee ballot must also be available as well. And that would apply to any association that decides to use the proxy. And if those things are there, then the proxy might be valid. One interesting topic or issue that may come up is whether or not a proxy that's created by an entity or a person other than the association will have to be honored by an association if it doesn't have all these specific components. The answer is probably no, in that the statute's pretty expressly sets forth what a proxy has to contain. And if a proxy is missing some of these items, an association would probably be within its rights to completely invalidate the proxy. Under current law and the recent changes, there really is an intent here for ballots to be both reliable, meaning they could be their eligibility could be checked down the road, and also be anonymous. And so an absentee ballot arrives. Traditionally, it was opened in an envelope. Obviously, it arrived in an envelope, or it was handed in, and then it was counted in the context of the election. Because of the new rules, the new laws, a lot of these practices really have to change. The absentee ballot probably cannot be accepted unless it's actually in an envelope or or it's received in some other way that would allow the ballot to be anonymous, but for the counter to connect it back to a specific voter. When absentee ballots do come in, there surely should be a setup already in place where those ballots in the envelope or that are contained in some other thing are put away and not really touched or made available to anyone until such time as they're ready to be counted and opened, which is really how they should come in. So an absentee ballot is basically going to be the ballot that would otherwise be utilized at an election if you showed up physically and in the more traditional sense showed up to an election and cast a ballot. The absentee ballot really shouldn't be much different than that at all, in fact. It should be sent, it should be received, and there should be really no distinguishing features between the absentee ballot and the regular ballot. They're both actually going to be cast the same way, especially in the larger associations, in that a ballot that's handed in at the actual election will have to also be tallied and collected in some way so that the ballot is anonymous, although the ballot can still be connected back to a voter. And the absentee ballot will have to be done the same way. So the ballot will always be, at this point now, free of any areas where a person can write his or her name and address, and will always be but will at the same time always be able to be connected back to the voter through some numbering system or some envelope system or some way in which that the association can tie a ballot that's anonymous back to a person who is the actual owner, who then can be checked for eligibility. Generally speaking, a proxy, as distinguished from an absentee ballot, would be valid if it was simply if it simply looked acceptable and was sort of devoid of any indicia of fraud. Currently, though, with respect to associations, a proxy has to have very specific things in it, or it will not be valid. It has to note that it's voluntary. It has to note that that it can be revoked at any time prior to being effective, and there has to be some notation as well that absentee ballots might be relevant and/or can be used in lieu of a proxy, and that if the proxy is not set up that way, if it's not sent in that way or not utilized that way, the association may not only have the discretion to reject it, but an argument could be made that it would have the obligation to reject it. So it's very important when proxies are created by associations that they be consistent with those specific requirements, which apply to all associations, not just those that are on the large side. As a result of recent changes in the law, it is clear now, although in my view, it was clear before, but it's very, very clear now that an absentee ballot and a proxy are not the same thing. Okay, an absentee ballot is basically a ballot that you would get if you were physically at the meeting, but simply you received it before the meeting and you sent it in prior, or perhaps even handed in at the meeting itself. But the ballot the absentee ballot is simply nothing other than the ballot itself that was sent to the voter prior to the meeting. A proxy does not indicate and should not indicate any particular vote. It's simply a document that will designate that will basically assign your right to vote to someone else. Practically speaking, if you are not going to be at a meeting, if you're not going to be at an election, I should say, there really is no reason to utilize a proxy. You should simply get the absentee ballot that you receive, you should fill it out, and you should send it in compliance with the rules. There's really no reason to then find someone, name that person a proxy, and then give them the ability to vote on your behalf, especially if you're going to direct the person to vote on the candidate or candidates that you want to choose. So in some ways, the new law has sort of made it, though it helps to distinguish between the absentee ballot and the proxy, it's also made it sort of irrelevant at this point to use proxies unless basically there's going to be something voted upon at a election or at a meeting that cannot be known ahead of time. But to the extent that the issue at hand is simply an election, where an identifiable number of candidates are set, there'd really be no reason to utilize a proxy over an absentee ballot. One of the issues that could force a voter to use a proxy would be if there's some write-in candidate that might be in play, or the voter believes there may be a write-in or some nomination from the floor someone brought up prior to the election at the time, and if you voted absentee ballot, you wouldn't be able to vote for that person. But if you assigned your right to vote to someone else who was physically there during the meeting, they would then be able to vote for the write-in candidate instead.